Welcome all. Thanks for joining us. My name's Garth O'Connor and this is Chris Bergen. We're going to take you through the world of Safe Harbour today. Safe Harbour being a tool to use for early intervention into financial distress. So we're going to take you through a case study today and put you in the shoes of the advisor to consider the issues and options and questions you'll be faced with when talking to your clients about financial distress and Safe Harbour being an option. This case study is based on the experiences we've picked up through acting as Safe Harbour advisors to a whole range of companies, ranging from small family-run businesses right through to ASX listed entities. There will be a quiz at the end of the session, so take notes and you can test yourself towards the end of the session.
Oh, fantastic. Thanks, Garth, and thanks everyone for joining us. So the case study we're going to go through today is Vanderlei Industries Proprietary Limited. And we're putting you in the shoes of you've been invited into your client's boardroom to help them consider their options and look at the risks by the facts and circumstances that's currently facing them. So the key facts are the business is a contract manufacturer, turns over about $10 million per annum, and it has a board of directors comprised of 3 people. It has a chairperson, a CEO, and a non-executive independent director. The company has approximately 30 employees who have some outstanding annual leave and some outstanding long service leave. There is a secured convertible note in place. Important to note that the company receives revenue in advance and it's facing or confronted by a number of financial distress factors at the moment. So it's experiencing negative equity on its balance sheet, declining revenue on its profit and loss statement, and negative cash flow. The accounts payable ledger is quite aged and is currently behind on its statutory debt. So that's the frame of what we're going to work through today.
Excellent. Now, probably the 2 main points to draw out of those facts are that there are 3 directors. They hold 3 very different roles within the business and their connection to the day-to-day operations of the business. That being said, all 3 share an equal risk when it comes to complying with their duties as directors and their duty to avoid trading whilst insolvent and having creditors suffer a loss as a result of avoiding trading whilst insolvent. So even though you've got a non-executive independent director who isn't involved in the day-to-day operations, that director holds the exact same burden that the CEO does. Second thing to note that although this company is displaying some classic indicators of insolvency, or certainly would be considered in the twilight of insolvency, there is something left to salvage. There is a business, there is turnover, there is loyal customers. So this conversation is being had at a time and is early enough to consider options, and one being some kind of restructure or turnaround under the umbrella of Safe Harbour.
All right. So first of all, we're in the boardroom with our client, and Garth, the chairperson, rightly asks you, tell us about Safe Harbour and whether you think it will help the company out given the circumstances it's currently facing.
I think the first point to note is that Safe Harbour, it doesn't grant any additional extra powers to the company itself. It is a regime to protect directors who act in good faith and look at options to seek to turn around their business and achieve a better outcome for creditors as a whole, and alleviate them of any potential future exposure to an insolvent trading claim. It's useful to look at the before and after. Safe Harbour has been around since September 2017, and before that date, directors were faced with the prospect of trading whilst insolvent and potentially being held liable or personally liable for the loss suffered by creditors as a result. What this meant is suddenly directors are looking inward and trying to make a real-time solvency assessment to see if they're exposed to this particular liability. Even in hindsight, solvency is a really technical and onerous exercise. You're looking at things that sit beyond just the balance sheet. You're looking at funding options. You're looking at trying to predict creditor behaviour. You're looking at the value of assets, contingent liabilities, future debts. And so, as I said, even in hindsight, that's an incredibly difficult task. And so you have directors looking inwards and worrying about their own personal liability rather than looking at the options available to turn things around. You move post-September 2017, Safe Harbour comes in. Yes, insolvent trading still exists, but you suddenly have this umbrella that can protect directors. Again, if they're acting in good faith, they can put aside the worry about their own personal liability and focus on the real viable options to, again, turn around their business and achieve a better outcome for creditors than an external administration. The legislation was drafted as a carve-out, and what this means is it flips the script from that pre-September 17 position to a point where a director is now innocent until proven guilty. What that means is that any debts incurred whilst the company is under Safe Harbour are carved out of any theoretical insolvent trading claim, whereas previously it was almost like the director was guilty until they could prove themselves innocent because they held a prima facie liability for any of those debts incurred at the time. As with anything in life, there are pros and cons to this process. The major pros being that it is a private process. It doesn't need to be disclosed to the public. You can choose to disclose it to certain parties where it may be beneficial. It is less costly than, or it can be less costly than an external administration. And you can also protect asset values, which may be diminished through the public process of an external administration. On the flip side, the cons are that, as I noted, no additional extra powers are granted to the company to deal with its creditors. The company isn't able to bind any dissenting creditors, and there is the potential for directors still to be liable for any debts incurred prior to Safe Harbour coming into effect.
Well, thanks, Garth. That's fantastic. So the board is interested, obviously, based on the facts and circumstances that they're facing. The board is interested in exploring Safe Harbour protection further. What for them is the next step in the process?
So really the next step here is that an assessment needs to be undertaken as to whether the company is eligible. And I like to break down the eligibility into two key elements. The first being governance. And really, the underlying basis for Safe Harbour is that it's grounded in good governance principles. So in terms of the governance eligibility, you need to be looking at your employee entitlements are up to date. Your tax reporting is up to date. You don't have to have paid your tax debts, but all the reporting is filed on time when it is due. The board needs to be informed on the financial position of the company. They need to have access to good, clean company financial records in order to allow them to be informed on the position of the company and make informed decisions. They need to ensure that no misconduct is occurring at the company on their watch. And then we move to the plan. Now, the plan as a starting point needs to ultimately achieve a better outcome for creditors, and that's creditors as a whole. So there is some complexity there, but as a whole, a better outcome for those parties than would occur in an external administration, being a voluntary administration or a liquidation. At all times, the board, whatever that plan may be, need to hold a belief that it is still reasonably likely to occur. So this is assessing the balance of probabilities. Nothing in life is certain, but if the board still hold a reasonable belief that the plan will achieve its goals, that protection remains in place. The board does gain protection as soon as they start developing the plan, as long as they don't develop the plan for an exorbitant amount of time. There is a level there they need to take action, but it does allow the board to seek the protection relatively quickly to avoid that personal liability crystallising.
All right, so Garth, as we said a couple of slides ago, we've got a board, and you went into further detail about this, a board that's comprised of different members. So the board is at odds with each other, but now that they've qualified for Safe Harbour protection, there's some different plans that they all might have. What are the considerations they might put in place?
Yeah, so we've got three different directors, three different people coming at this situation from different angles. We have a non-executive director that has looked at the situation and felt there is no achievable plan. If this was the case, the reality is the board should move swiftly to planning and appointing a voluntary administrator or liquidator, because there is no achievable plan, there is no safe harbour protection, and they are exposed to those debts that are occurring whilst they're making those decisions. So you do need to move quite swiftly if, in fact, there is no plan that can be reasonably achieved. You have the CEO, who's ever the optimist, and they are talking up a growth and efficiency-based plan. My view is that by the point that a company is in that twilight zone of insolvency and needing the safe harbour protection, making improvement around the edges and looking at long-term plans that involve growth in revenue or reduction of headcount or other bits and pieces is really a little too late. These kind of things probably should have already been looked at before it got to this point. So really hope is not a strategy, and some of the things that would come with a growth and efficiency-based plan would fall into that hope category, and also probably wouldn't be able to affect enough change in the short period of time needed to turn things around. So it does leave us with the chairperson, who has suggested a debt restructure, new funding to come into the business, and a pivot in the strategy of the business. Now, this obviously has legs. There is some substance to this particular plan, and yes, pending the benchmarking exercise, which we'll touch on. At this point in early days, there does seem to be something feasible there, and it would be appropriate for the board to consider that this is a plan that is reasonably likely to succeed. We have the convertible note holder that comes in, converts their current debt into equity. They also tip in some more funding to bridge the gap in cash flows being created by this distress. There's a replacement of the board, and that board will implement a new strategy that may look at new customers or a new market to ensure the long-term viability of the business. Some other scenarios that are appropriate for Safe Harbour could be if you're looking at some kind of white knight investor. You're looking at new financing or restructuring your financing with a bank or a lender. The company might be subject to litigation that would have a material effect on the business if the business fell on the wrong side of the litigation. So anything with uncertainty, it would be prudent for a board to seek the protection whilst that process plays out.
All right, so next we're going to look at where accountants, it all comes down to the dollars and cents. So Garth, going to walk us through what those scenarios look like in the dollars and cents terms for the individual categories of creditors, as well as the ongoing business.
Yeah, so as Safe Harbour advisors, we need to assess whether the plan is going to lead to a better outcome for creditors. The board needs to satisfy themselves that at all times it is reasonably likely to succeed, but at a black and white level, whether it is a better outcome is going to come down to the numbers and the dollars. And how we'd approach this would be to pull together an outcome statement and looking at the different classes or categories of assets and liabilities and assessing those values in an optimistic return situation, which would be something like a going concern trade sale through an administration, or a pessimistic return where you're looking at auction realisation value for assets in a shutdown liquidation scenario. So going through the different categories, you're looking at circulating assets, so they're your cash, your debtors, your inventory. As you would expect, in any kind of shutdown scenario, those kind of assets, particularly debtors and inventory, would decrease in value quite significantly. If you're looking at your non-circulating assets, that's your plant and equipment, that's your goodwill, your intellectual property, your trademarks, your brand names. And again, these are going to be impacted impacted by whether the company is going to continue as a going concern, or whether you need to shut that business down and realise these assets piecemeal. And some of the issues we look at when valuing these kind of non-circulating assets is the business making a loss? Is the book value a reasonable starting point for an estimate on the value of assets, or is there some kind of specialist valuation that is required in the process? And that's an assessment we make at the time. Again, if there's a big buffer or margin for error in our assessment, a high level assessment is okay at the start. As that margin for error becomes smaller, you may need to drill down and actually get some more specialist advice on how to value some of these assets and liabilities. Employees, obviously in a going concern situation, their entitlements aren't going to crystallise. However, if they need to be terminated, payment in lieu of notice, redundancy, all these kind of things will crystallise, and again impact based on the waterfall of assets on what other categories of creditors would receive in an external administration. Secure creditor, again, because of the decrease in the asset values in a liquidation scenario, they are likely to suffer a haircut. So that's something for the board to consider in the process. And in this situation, in a going concern VA scenario, unsecured creditors are X, $3,000. That does increase in our shutdown scenario because of some of the revenue received in advance, which will then crystallise as a liability because those services haven't been provided. And in this scenario, you can see that even in a going concern trade sale VA, unsecured creditors are likely to only get 17 cents in the dollar, and in a shutdown scenario, likely to get nothing, no return. So it's pretty clear when we're looking at a plan around a restructure and a full payout of creditors over time, that the plan under Safe Harbour is a much better outcome for all creditors. And again, there is a big margin for error in this assessment, so the board can move forward with confidence that their plan has merit and they're going to be sheltered by that Safe Harbour umbrella. This benchmarking statement is refreshed from time to time. If the return to creditors is eroding rather than increasing, that's just another data point for the board to assess on whether to forge on with the plan or seek some kind of external administration.
All right, now time for a quiz. Hopefully we've covered off all the answers to all the questions as we've gone through the slides. The first question, and we'll give you a few moments to answer at home. A company must have paid all of their tax debts to be eligible for Safe Harbour. Is the answer to that one true or false?
So the answer, of course, is false. The company needs to have had made all their lodgements that are required from time to time, but they do not need to pay their tax debts as and when they fall due. The company is also able to apply for a payment arrangement through Safe Harbour and not disrupt the protection that is afforded the directors.
Excellent. Second question, does the company have protection if they are only in the development phase of the turnaround plan? True or false?
This is true. As touched on earlier, the board does have time to sit and consider and deliberate on what plans or options are viable, and then make a decision on which path to take. And throughout that period, as long as it's reasonable, and they're taking action in a reasonable amount of time, they do have that protection as soon as the process starts.
So, number 3, what are the criteria for the advisor engaged of the Safe Harbour process, i.e. who can you engage to do this work for you or with you? A registered liquidator, someone who's appropriately qualified, someone with restructuring expertise, or someone who is admitted as a lawyer? Garth.
Now, the answer as drafted by the legislation is that it is someone that is appropriately qualified. I think when you're choosing your advisor, you want to have consideration for the issues facing the company, and it may well be a combination of the other areas of expertise that are on your screen at the moment. or even a team of advisors, depending on the complexity and the size of the business. But the legislation was drafted in a way to allow some flexibility in who a company engages based on their situation and the complexity of their business.
Excellent. So question number 4, what group of creditors get access to priority access to circulating assets? Is it secured creditors, employees, unsecured creditors, or customers who have paid in advance for services?
So circulating assets, as noted earlier, are those that involve cash, debtors, inventory, and in an external administration process, employees get access and priority access to those particular assets ahead of even your secured creditors or even those customers that have paid for services in advance.
I'll just ask the question. I'll get you to go through the guts of this one, Garth. Does the following scenario qualify as a better outcome for the company?
Yeah, so again, drawn on some of our experience and what we've seen advising different companies, and this particular scenario, the process is used to position a business for a sale to related parties. It is at less than market value, and the outcome for the different creditors are that unsecured creditors get nothing, although they do get the opportunity to continue trading with the business. Secured creditor rolls over their facility to Newco and gets a full return over time versus suffering a haircut through the liquidation process. The director avoids a call on a personal guarantee that backs up the security held by the secured creditor to the company assets. And some of the employees maintain their jobs whilst others are made redundant. They get their entitlements, but are made redundant. And ultimately, this particular question, although it has some positive aspects in the situation, it does come down to the 2 items that are underlined on your screen. Because the business is sold at less than market value, that is an issue. And you would argue that if the business was put to market and possibly through an administration, the value achieved could be higher. And you would also see some of these other things being ticked off as well. Unsecured creditors may receive something. Secured creditor, as long as they saw a benefit in it, in rolling over the security or they get paid out, they would approve it. The director would avoid the personal guarantee. You need to be careful about using Safe Harbour to drive any personal agenda or personal benefit. And again, if you sold it at market value, again, some employees may maintain their jobs. So there is some subtle nuance in that. And it's the fine lines that you need to tread when you're restructuring under the bounds of Safe Harbour to make sure you're securing that protection. So that's it for us. Feel free to reach out to Chris or I if you've got any questions stemming from this video, and look forward to seeing you all again soon. Thank you.
Thanks for watching.